Well, it gives me great pleasure to welcome Professor Werner Scholtz to Griffith for the second time in as many years. I was unable to make face-to-face acquaintance last time, although he was up here for Stevens White's workshop on animal law last year, which was a resounding success. He's here this year visiting QUT and has kindly consented to come up and talk to us about the tensions in the rhino horn trade that arise on account of the idea that you can commercially and somehow sustainably utilize and exploit rhinos and their horns, and at the same time save them. And I think that's the essence of what Werner will talk to us about today. And with that, I'll turn it over to you, Werner.
Thank you, Don. Thank you for the invitation as well. It is always a pleasure to visit the university. Before I commence with the discussion and the presentation, maybe just a caveat applies, and this is quite a broad topic, and you can approach it from various perspectives. I'm not going to cover all those areas. I will not use empirical data, for instance. The whole idea is to actually reflect on this issue from a legal perspective, and you'll see I will restrict that discussion even further. So that is just important to realize. Just by way of an introduction, if we look at the statistics, you might be aware of the fact that poaching has been on the rise, and my focus is specifically on Africa due to the fact that this is where the majority of poaching occurs in relation to the black and the white rhino. And you can see that there's a tremendous rise in Africa, 1,342 incidents of poaching in 2015. I recall that in South Africa, if you look at the statistics, from a certain benchmark, I think it was in the late 90s until now, there's something like a rise of 90% of poaching. So it's quite overwhelming if you look at the statistics. Now, of course, South Africa conserves roughly 79% within Africa of the rhino population, and has faced 88% of poaching, worldwide poaching, since 2010. So quite astounding figures. Now, the two species that I want to reflect on, which occurs in South Africa specifically, is of course the simum, that is the white rhino, and within this group you have the northern and southern white rhino. The northern rhino has become more or less extinct, and the southern white rhino is actually relevant in relation to our discussion. It occurs in South Africa. It is on the IUCN red list, designated as near threatened, whereas the black rhino is critically endangered. So those are the two species that I'm going to discuss today and use as a sort of a case study. Now, why do we have this this tremendous increase in poaching? Is of course due to the global demand, which is fueled in Asia, predominantly by virtue of two aspects or two issues. The one is the fact, this cultural belief that rhino horn can, for instance, cure cancer, which is of course not true. And also it is used in Vietnam, for instance, at social parties. They mix it with wine, the rhino powder, in order to indicate, of course, wealth, affluence, and so forth. So those are the two predominant usages. So you spoil your wine with keratin. That's actually what you're doing. It's quite ludicrous. Now,
that's just the wine's really bad.
Well, that's also true. That's just as a sort of factual background concerning the presentation that I would like to give. Now, of course, in doing this, we need to take cognizance of CITES, the convention that deals with the regulation of trade of specimens and species of wildlife. And you've also referred to the crux of the matter. So the question here that I'd like to address, and that if you deal with this issue of rhino horn, is mostly that if trade is allowed in terms of international and national law, then this sustainable utilization through trade may actually benefit wildlife due to the fact that will have economic benefits that can be used to conserve. So for conservation purposes. That's why I've said it's the argument of sustainable use that leads to conservation. It's also applicable in South Africa, and it's also reminiscent and reflected in the current discussions in South Africa, where we had a moratorium on domestic trade in rhino horn, which has now been replaced with draft regulations on domestic trade. And one of the major arguments that you hear is that it will actually benefit conservation, it will benefit wildlife, because it will have certain incentives to conserve and protect rhinos. And if we talk about this issue of sustainable utilization and commercialization through trade, there are certain activities that we just need to mention. The one is, of course, trophy hunting. The other is harvesting. So that's where you've got captive and animals, and you harvest through a painless, I'll explain that later, process, the rhino horn. You have also the collection of rhino horn from natural death, and also recovery from poaching. So we have the state, for instance, possesses stocks, a stock of a certain amount of rhino horn, and that can then be, of course, sold via auctions. So those are some of the typical activities relating to the issue of rhino horn, this idea of commercialization, commercial trade, being actually conducive to conservation. So that's one side of the coin. Now the matter becomes even more complex, and this is a very heated debate. Before we move to the next issue, it is already very heated whether this is indeed the case. And I don't want to reflect too much on that. There's quite a range, a myriad of scholarship that deals with this issue. Now, if we discuss the other side of the coin, and that is frequently from the side of the exponents of animal rights and animal welfare, that voice the concern that this trade, this commercialization, is actually a form of instrumentalism, and that you need to take cognizance of the welfare of the individual rhinos. And frequently it does not really feature in the debate relating to trade and conservation. And that is my sort of entry point and interest, is the issue of what happens actually, or what is what are the results when you insert the issue of animal welfarism in relation to this debate on trade and commercialization. And there we, of course, need to reflect on the emergence of animal welfare in especially international law, the implications in relation to wildlife welfare law, and of course the issue of conservation. That's what I'm going to do briefly, is to make an assessment or appraisal of the link between trade, the commercialization, sustainable utilization argument, and conservation, but within the context of this relationship between welfare and conservation. And I'll do this by referring, first of all, I don't know, I must maybe first ask you a question. And the question would be, how well are you acquainted with the complex structures of CITES in relation to this issue? I don't know. So what I'll do is I'll give you sort of a crash course and refer to the most important issues, and then from that move to the South African perspective, because that's where the battle is currently taking place, and from that generate certain conclusions in relation to this question that I've just asked. So I'll briefly deal with this, just give you a summary of CITES. And I've referred to the fact that it's quite complex, and it is indeed. It has various exceptions and exemptions in relation to this. But very, very briefly, the CITES Convention relates to trade in specimens of species, which is defined in Article 1 of the Convention, but also in a readily recognizable part or derivative. So the horn of the rhino also falls under the purview of this definition, Article 1. It also, this Article 1 definition also allows for so-called split listing, which is important for a discussion that we'll have, which means that you can list in one of the appendices a species or a specimen of a species in a different geographical location, and I'll explain that shortly. Just keep that in mind. But essentially what CITES provides, it is an instrument that deals with trade in wildlife through a system of permits and appendices. So you have the three Appendix 1, 2, and 3, different tiers. So you can see Appendix 1, species threatened with extinction, 2, not yet threatened, and 3 relates to domestic regulations, species not listed in these appendices, but which may have fauna and flora legislation pertaining to those species. And essentially what CITES does is, in relation to the different tiers, it prohibits international trade unless you have a certain permit or permits, it's actually mostly permits, in relation to export, import, and re-export. And it depends, of course, on the different tiers that you have. So you have different permit regimes pertaining to the different degrees of extinction. And I'll just give you one example. The one that we are going to deal with is Article 3.2, which deals with an export permit which is required for a Appendix 1 species. That's the threatened species. And you can see what needs to take place. There needs to be from the state authority a determination that the export will not be detrimental to the survival of the species. You have the domestic laws requirements, so that it's not obtained illegally, and lastly the welfare requirement. And then you can provide an export permit. But before you can obtain an export permit, you need an import permit. And very important in this regard is this sub-article C. An import permit cannot be issued when that, and in this instance in cars, the rhino horn is used for primarily commercial purposes. Essentially it means that an Appendix 1 specimen may not be traded commercially. And now the question is, what does primarily commercial purposes mean? It has been deliberated upon and defined in terms of subsequent COP resolutions, which I will not really discuss now. Resolution Conference 13.7. So the main idea is you need those permits before you can trade, import, export. You need to comply with requirements. Appendix 1, no commercial trade for primarily commercial purposes. That's the prohibition. There's an exemption in relation to that prohibition in Article 7.3. This exemption relates to the fact that the Articles 3, etc., does not apply in relation to specimens that are personal or household effects. What does that mean? And once again, it has been dealt with, for instance, when you are moving towards another country and you have rhino as part of your household, it can be covered under that. That's one of the possibilities.
So you've got some antique jewellery or something? Or
yes,
you just
and it's for personal
full
use. It was for personal use, and you have it as part of your luggage, for instance. So that's the exemption in relation to the prohibition. And then you don't have this.
They wouldn't be commercial purposes anyway, would they? Having it for personal or household.
So that's exactly the thing. So it's not a commercial use.
Yeah.
It's an exemption on, so any personal household effects, well then that will not apply because it's not for a purpose of primary commercial purpose. Okay. But the exemption, so that exemption is also excluded where you have, and this is typical in the so-called instance of silo rhino horn trophy hunting, where you have an owner outside his state of usual residence. You have a Vietnamese person. He's traveling to South Africa. He's shooting rhinos and then taking that back to Vietnam. It does not apply. And then in addition to this exemption in 7, you have exceptions also. Those exceptions, the two that I'm going to focus on would be the issue of hunting, trophy hunting. There are two exceptions in relation to that in terms of crops. And then the other is the captive and, well, let me just say captive bred rhino horn products. So what does it mean? In terms of the CITES, the first COP in 76 already listed the whole family. You have 5 different species of rhino. We're dealing with 2. There are subspecies as well. Listed that whole family on Appendix 1, which essentially means that you cannot trade for primarily commercial purposes, but you have an exemption, which sometimes does not apply, and you have exceptions. So that's how CITES actually, in a nutshell, and it's really in a nutshell, regulates this issue. So essentially, you cannot really trade black and white rhino horn. But there are once again certain exceptions which I've referred to. And for this, the southern white rhino, for instance, what occurred was there was a sort of a replenishment of the southern white rhino to such an extent that split listing occurred. I've referred to split listing. The fact that in South Africa you have, and not only South Africa but also Swaziland, you have a number of southern white rhinos that have been conserved. So they've been moved to Appendix 2. So Appendix 2, that prohibition does not apply. You need different permits. Not the prohibition does not apply. But it includes a so-called, what they refer to in CITES, annotation. So it's very specific. So it has been moved from 1 to 2, making it, of course, easier to trade, but only for the exclusive purpose of allowing international trade in live animals to appropriate and acceptable destinations and hunting trophies. So it's very specific, that annotation. Okay. And then, of course, the trade ban does not apply, but you need to have an export permit and so forth, and a different article provision applies in relation to that trade. Then there's also, in relation to black rhino, the Resolution Conference 13.5, which allows for a certain quota of hunting trophies. Once again, hunting trophies in both instances. 5 hunting trophies of adult male from South Africa and 5 from Namibia per annum. Yeah, sorry.
Is that annual export quota per person or for the whole country?
Per annum.
Yes, per person. Or per
for the country.
For the country.
Yeah,
no, only
not,
5
so
the
hunter
whole
can't.
country.
Yeah, there's a hunter can't enter and then take 5 of that. So it's for the country. Yeah,
Okay.
and it's for trophies once again. Okay. The resolution. So I've mentioned this here. Does it have a laser thing? No. Okay. So if you read further that this 13.5, and so it's not only you can't merely take those moves. It once again has a very clear guidelines on this issue, because it's not concerned to be trade in terms of the commercial trade. If it complies with those requirements, the trophies are being imported as personal items, and owner may import only 1 trophy per calendar year. So that's the hunter. It takes 1, but you have 5 hunters. Okay, and it's not considered to. It's considered to be personal. It's under the purview to an extent of personal and household effects. So those are the exceptions. And the last interesting thing in relation to trophy hunting, which is applicable to 13.5 as well as the downlisting, is the fact that Resolution Conference 17.9 recommends that trophy hunting must provide benefits to local communities. Why am I referring to this? Because it once again slots into this sort of this approach that we can trade rhino horn and it will benefit local communities, people, hence there's an incentive to conserve the species. So that's the whole thing. If you read that resolution, it's very evident. So in a nutshell, that's the story of trophy hunting and the lists. But there are also certain further exceptions, and that is the captive breeding of rhinos. But once again, and that's in terms of Article 7.4, the requirements are quite strict, because obviously this could create a loophole of abuse. Because how do you determine we've got a captive bred rhino, and it's quite difficult. There are certain technological advances that they've now made, but it's very specific. In the instances where you have captive bred rhinos, then it is deemed to be an Appendix 2, so once again the trade ban does not apply, Article 4 permit process. But there are certain requirements, and you can see the requirements there that the guidelines issued by the COP in relation to this. So that serves as yet another exception. So you've got an exemption, you've got trophy hunting exceptions. So it's a complex thing. And the majority of this, of course, not in the CITES text itself, not always.
So when were these resolutions introduced in the CITES? I doubt that they were in the original.
No, so it's not in the treaty itself. So through subsequent COPs, this was introduced. 1980s, 1990s? No, it's quite recent. Some of them are quite recent. Some of them are quite recent. Some of them COP 2014. But some of them are quite, not in the 8th, this is not from the 8th. For instance, the downlisting occurred, I think, in 94, was it? 92, 94? Yes. So it's not too far back. So I just want to mention wildlife ranching, because that's a distinction between captive bred and wildlife ranching. This is where specimens are taken from the wild. And in this instance, parties can transfer the populations of species from 1 to 2 in order to escape the commercial ban. There was an instance of sea turtles, I think, at some stage, which they transferred, but it has not occurred in relation to the rhino. So currently, this does not apply to rhinos as such. And even, yes, so those are you need to distinguish wildlife ranching from captive bred. But for our discussion, it's not really that relevant because it has not occurred as such. So that's in brief the regulatory framework. And once again, I've just mentioned some of the issues. It's even more complex. But I've mentioned the main issues that could apply in relation to our discussion. If one refers to the issue of CITES, it's also important, of course, to focus on its shortcomings. It has been held as one of the most successful environmental treaties, but there's also reason for caution. And a number of scholars have dealt with the issue of the effectiveness and so forth of CITES, so I don't want to repeat the scholarship in this regard. I just want to focus on some of the issues that we're dealing with, and that is, of course, trophy hunting, captive bred, stockpiling, and so forth. The one thing and of course specifically in relation to Africa and South Africa, the one major problem in relation to CITES is, of course, the fact that it depends very much on the member states, the implementation of CITES for national legislation in domestic jurisdictions. In South Africa, we currently have a major problem of corruption. It was to such an extent that it was found, we have a term now for the state capture. Essentially, it was discovered that the previous president sort of ran a mafioso state. So corruption is a major issue. Capacity is another issue, because you need to have clued up officials at the border that can now deal with this. I mean, it's extremely technical. So that's a major problem, of course, especially in developing states. Then another issue is the interpretation of CITES, these exceptions, exemptions, the text and the resolutions and so forth. That creates a problem. But you also have a differentiation in relation to the approaches. For instance, you may have some developed states that consider the conservation of megafauna imperative, whereas developing states may see this as a something for economic gain, the exploitation. So very difficult. And also another issue which is important is the listing in the appendices. Frequently this is, unfortunately, guided by short-term economic interests rather than conservation. Of course, welfare does not even feature on, because it deals only with trade and biological criteria. So that's another issue. And one could, of course, from a welfare perspective, make the argument that essentially CITES, which facilitates trade, is actually an instrument that approaches animals from this instrumentalist anthropocentric approach. So it facilitates and authorizes trade in commodities. I just saw this again, when was it? In Australia, one of these souvenir shops, they have kangaroo products, and then they've got a tag on it. It's been harvested in a very humane. And I thought about this with harvested. You know, it's like you're going out and harvesting something from it's very similar in this regard. It's a living entity, a sentient being. It can't be harvested. So that's it facilitates and entrenches that position of dominance to an extent. Although, and I need to say this because it's quite important, it does include, which is very interesting, a number, and I refer to some of them, welfare provisions, which seem to be incidental. And Michael Bowman has actually written a very good article on, something like 70 pages on this issue. But it's not about welfare as such. It does have anti-provisions relating to welfare. For instance, but the main issue is, of course, the taking. It has been clarified previously at one of the COPs that the manner in which you take or harvest an animal is not to be regulated by CITES. So welfare is not the predominant approach in terms of CITES, but it has this sort of possibility, this loophole, this backdoor. So those are some of the critical issues. I'm not going to deal with this in detail. I just want to mention it, to give you sort of for reasons of being comprehensive. Is the fact that South Africa has to an extent duplicated this approach through national legislation, in also permit system, tier system, and so forth. The interesting thing is, if we now move from the international perspective to its a more domestic perspective, is of course the fact that in South Africa we had this moratorium on domestic trade. Subsequently, a procedural requirement in relation to the notification in a newspaper was not done by the minister, so on the basis of procedural grounds, that moratorium was set aside by Mr. Hume, which is he has the largest number of rhinos in the world, but also stockpiles. I can't remember the exact amount, but it's ludicrous, it's unbelievable. So he, of course, can gain economically if this moratorium is set aside. And it was set aside on procedural grounds. And in that case, the judge never referred to the fact that it was ultra-virus, or just the fact that procedural requirements were not met. That was it. Subsequently, rather than rectifying the problem, what the government did was, and I think it was also through lobbying, of course, they recently published draft regulations which now allow for the domestic trade in rhino horn. I'm not going to discuss it because if one analyzes it, it also becomes a bit problematic. Certain questions arise. One such an issue is that, of course, it relates to export, to domestic trade and export for personal use. No, there's no sane person in South Africa that will buy rhino horn. It just doesn't have any usage. So you can't. So there's no need for it to trade it in a domestic manner, in an auction or something similar. And it begs the question whether that exemption will then be applicable in relation to a foreigner that buys the rhino horn and takes it outside of the country. So it's very problematic, the domestic trade in rhino horn regulations. So let me just recap what I've said. I've briefly provided you a factual background of the issue and problem. I've introduced the complex regulatory frame of exemptions and exceptions. I've indicated that one of the major problems is the approach of CITES. If one takes, of course, this is a convention from '76, but we're in a different era. We're now in 2018. We are aware of the fact that animals are sentient beings. It follows that approach. That's why I'm saying I'm not a toaster, because that's what we actually, if we deal with animals in this manner, it's like you're buying a toaster or a microwave and then you dispose of it and buy another. That's sort of the approach that we are following. For me, the interesting question that came to mind was in reading the legal, especially the legal scholarship in this regard. There was scant regard of the emergence of wildlife welfare issues. And that's why this is actually based on a chapter that I've written that will be published, I think, at the end of the year. It's a book on animal welfare and international environmental law, which I'm editing. I'm now using this also to promote my book. It's horrible, I know. But I'm just mentioning it. And I considered what are the implications when you consider, when you're thinking that a rhino and a rhino horn is actually not a toaster that you buy. So this is the third part of the presentation, where we consider the issue of animal welfare. And it's the first issue is, of course, I've mentioned the moral significance. There's the scholarship that has emerged which indicate that animals, and in this instance wildlife, has moral and legal significance based on various factors. One of them could be sentience. We can discuss that, but sentience is one of the interesting aspects mentioned. We also see that the Convention on Biological Diversity actually, to an extent, dilutes this concept of instrumentalism, this instrumental approach to animals, as it refers to different values in the Convention. Most important and interesting being the fact that in the preamble it refers to intrinsic value of biological resources. So that's different from instrumentalism. And I know
it still calls them resources.
Yes, of course, but you can. It's a very broad concept where rhinos and rhino horn fall under. Of course, it's only in the preamble, and we can have discussions on the legal interpretation and the effects of the preamble. But it's mentioned, and you can also see some of the strands in the convention itself and further soft law documents. Bowman, Davis, and Redgewell in the 2010 Licensed Wildlife Law edition has a chapter which is quite interesting on animal welfare. And in that chapter they mention that intrinsic value of wildlife, which I've just mentioned, means that any sound ethical policy should additionally have regard to the extent to which individual organisms are permitted to flourish in accordance with their biological nature. And it's in this vein that discussions concerning animal welfare, but specifically wildlife welfare, emerged. And then of course the argument is made by these three authors in the book. I think Peter Davis wrote that chapter, that there is a convergence upon a principle of animal welfare law in international law. And it's quite interesting, the argument that they make is they use the statute, the General Principles of International Law, Article 38(1)(c), and I'm not going to deal with this in detail. I've written an article on this which indicates that it's an interesting, or it's a possibility, an avenue that one could utilize, also by virtue of the fact that General Principles of International Law are not, not readily used, but it can be based on national and international resources. There is quite a considerable amount of national legislation pertaining to the issue of welfare, not always in the wildlife realm, but in relation to animal welfare, domestic and companion animals. And in terms of international sources, we also find some interesting soft law documents, such as the Addis Ababa Principles, which I'll refer to later on, in relation to biodiversity. And just, this is of course not to say that animal welfare is already a general principle of international law, but it is a possibility, and there's an emergence of this. And I've discussed this issue further by reference to a book of Christina Voigt on sustainable development as a general principle of international law, which indicates this is a possibility. So there is this potentially emerging principle, and implications of such a principle, I don't want to deal with all those issues, is the possibility that it may function as a meta-principle, as referred in Article 31.3c of the Vienna Convention, the law of treaties, where you can, in a substantive manner, interpret treaties. So there is, what I'm trying to say is there is this movement in relation to animal welfare which is connected with the recognition of the intrinsic value of wildlife. Now, that argument resonates to an extent with a recent case in South Africa of the Constitutional Court in 2016. And I must sort of also provide a caveat here. I'm not sure whether the judges actually realized the extremely profound nature of this case and the radical paradigm shift that they introduced in deciding this case. I just want to mention a few of the things, because we had a relatively conservative approach to welfare. It was predominantly focused on the idea that you do not want to infringe on the sensibilities of people, so not the welfare of animals, but it's actually regulating welfare of animals by virtue of reference to the sensibilities of people. And in this case, although there was some sort of a progressive development in relation to that issue, the judges said the following. They specifically mentioned that there's an intrinsic value of, or the recognition of an intrinsic value of animals, individual animals. Now that may not seem to be that radical, but what they, and this is in analysing and interpreting Section 24 of the Constitution of South Africa, which provides for an environmental right, not for animals. Environmental right, which is overtly anthropocentric, actually, if you read it. So once again, it also includes inter and intragenerational rights. It's about people, not animals. But in interpreting that Section 24, they also said that constitutional values dictate a more caring attitude. Now, if you read scholarship on animal welfare, caring and compassion frequently are well-known terms. And then, most interesting is the fact that in relation, and the judges couple this directly with biodiversity legislation. In the context of biodiversity legislation, animal welfare and animal conservation reflect two intertwined values. It's an absolute paradigm shift because previously, in a Supreme Court case, the court decided that biodiversity legislation does not cater for welfare at all. It's not supposed to. It doesn't deal with ethical issues, only conservation. Very strict. So that's a sort of a paradigm shift. So from the development and maybe I should also add in relation to this argument, what I've noticed subsequently is, of course, considerable scholarship on the issue of animal welfare and law and international law, and even now wildlife welfare and international law. And then on the South African level, something very similar, which is even much stronger. And once again, I refer to international law and South African law by virtue or due to the fact that we're dealing with the specific causes. So something that is regulated on the national plane, but also on the national plane occurs predominantly in South Africa. So if we evaluate this case that I've just mentioned, what are the implications of this case in the context of our discussion. One thing is, of course, that it may contribute to an extent to this sort of establishing the general principle of international law by virtue of the fact that South Africa follows a stare decisis approach. So one can discuss that as a potential contribution. But there's also, of course, the issue of so-called transjudicial communication, of which Anne-Marie Slaughter has written a great deal about. So it can contribute to this emergence of wildlife welfare and a relationship between conservation and welfare. Before I continue, how much time do I have?
You can say another 5 minutes.
Okay, so I'll sort of conclude. So it actually contributes to the emergence of this, and the reason why I'm referring to this is the fact there's a dichotomy between conservation and welfare. There's still seen as two opposing issues, where conservation or welfare deals with issues of ethics and recognition of the individual welfare of animals. Conservation is science-driven, but there's also overlap, of course, as seen in the Whaling Convention in relation to the usages of instruments to harvest whales once again. So it's interesting how it influences this debate between conservation and welfare and the need to reconcile this. And this tension, of course, and now I want to revert back to the intrinsic value of wildlife, is of course, if there is of course this tension between the two concepts, but intrinsic value recognizes that there's a good of its own and a good of its kind. And good of its own, those are both sort of two sides of the coin. Good of its own being, of course, the fact that an animal, a rhino, needs shelter, it needs food, and so forth. But it's also good of its kind, the fact that it forms part of a species. And both of those elements are required in order to conserve species. And so one also needs to take cognizance of this issue, and it allows for a reconciliation between conservation and welfare. Briefly, what are the implications for CITES? I just want to briefly talk about implications of these arguments. Very limited, of course, the fact that listing does not deal with this issue is one aspect. Taking from wild, so essentially not a major impact on CITES as such in relation to the issues that we've dealt with. However, of course, CITES allows for the adoption of stricter domestic measures. So from a domestic point, it may have an impact which is more considerable than the allowed for by CITES itself, regarding, for instance, the way in which an animal is hunted or so forth. Okay. I think I have 3 or 4 more slides. Oh, no, it's more. Okay. But I'll go through it. Okay. What are the implications of this in relation to our current issue? And I want to take you back to what I said in the beginning. The issue here is the approach of commercialization as a means to pursue conservation in the context of rhino horn. The first thing is, of course, that if one accepts the case, the South African case, the findings, as well as the emergence of animal welfare, it's quite clear that it has an effect on sustainable development, and more specifically sustainable utilization, sustainable use, which is a component of sustainable development. It inserts an ethical element which is closer to the guidelines, I think it's Principle 11 of the Addis Ababa Principles on Sustainable Use, that refer to an ethical and humane use. So it sort of brings this, or injects ethics, an ethical element, a more ecological sustainable use approach. It allows for a sort of a departure from dominance of economic influence and instrumentalization towards a recognition of the intrinsic value of individual animals. So in this context of trophy hunting, which I've discussed previously, if you take that causes, it does have a bearing on this, in the sense that now, when you balance in sustainable development the 3 pillars, the environment, the social and economic, in this context, you recognize the individual interests of the sentient beings in a single biosphere. So there's a dependence on this communal habitat. I refer to as welfare-centric, but I'm not going to discuss it now. We can discuss it afterwards.
With the interjection, maybe we
Yeah.
can interject now.
Yes, sure.
So the introduction of the ethical component in this idea of the pillars of sustainable development, does that result in any sort of limits, in law that beyond which the law will say you cannot go? That's for sustainable development or sustainable utilization through commercialization. I always find the ultimate limit a problem, because sustainable development, is a balancing act, and it seems, while ethics and ethical consideration are now in the mix, they aren't certainly any sort of veto or limit. I don't know what your thinking is on that.
I have a slide on, I'll try to explain or try to address that, and then we can discuss it maybe afterwards, because I have something that it's of course it's a very difficult question, because sustainable development is fake, and it has a sort of the economic interests in my view are mostly predominant. And that's why I'm saying that in this instance, at least, you take cognizance of a more ethical, what is ethical insertion of the welfare of a sentient being within this balancing act. But I'll try to explain it in terms of trophy hunting, and then maybe, yes. For instance, this recognition of intrinsic value and animal welfare does not imply that all forms of pain and suffering must be avoided. It's different from the animal rights movement. But that rhinos cannot be merely used as tasters. They're not tasters, not microwaves, to satisfy predominantly our human needs. And I hope some of these things I hope will clarify what you've just mentioned. What does it mean for our debate if we take cognizance of this development or these developments? It means that in this, this discourse, trade conservation discourse, sort of ignored the welfare issue. So there needs to be a cognizance of the relationship or the interwoven nature, as mentioned by the court, between welfare and conservation. What does it mean? And I've used trophy hunting because that's really provides a very good causes for a practical application of these findings. So from my perspective, if I consider trophy hunting, that's what I've said there. It's a wanton and frivolous killing of an iconic animal for pleasure. I find trophy hunting disgusting and ludicrous. But it's subjective. The question is, so what are the implications in terms of law? So if I think about what I refer to as an integrative approach, respect and caring, conservation and welfare, I think it contradicts that. But it's very subjective. The truth is, of course, the argument is that it encompasses economic benefits for people. So in trophy hunting, frequently the local community facilitates the hunt, they get the bushmeat, and so forth. And so it does provide them with benefits. And that could serve as an incentive for conservation and ultimately serve as something that benefits wildlife in that sense. So one needs to take cognizance of that component. And then it becomes more complex. You can't merely state that trophy hunting, in terms of animal welfare, in terms of this matrix of sustainable use, is now prohibited. Because then you ignore the different elements of sustainable development. The thing is to inject the ethical part and ask the question, so what does it mean now? And I think that if you do that, it provides you an interesting picture. Not to merely reject it, as I've said. It's frivolous, it's wanton, but to take cognizance of those other elements. And if you have a careful evaluation of the injection of the ethics, what you then see is you have a balancing of the environmental component, the ecological component, conservation, but also compassion, the economic, the fact that you generate, for instance, funds, and I'm using this trophy hunting as a specific causes now, and also the social component, human rights issues. So you need to still have that balancing act. And when I refer to sustainable development, I also do it with a caveat that it's vague, that it's not easy to implement, that I think the economic interests are frequently at the forefront. But there is a sort of a change that occurs when you take cognizance of this emergence of animal welfare, both on international and national plane. And the question that you then need to ask is whether use is sustainable. So it's a very difficult issue in this regard. Let me just say one thing. So I've used the trophy hunting causes. If we move on to the captive breeding causes, it's also a difficult issue. The fact that the one concern that I have is the transposition of this model to wild animals. It raises some, it's very similar to the factory farming that we have. So that's one concern that I do have. Another issue is, of course, the fact that if you file rhino horn, it is said that it does not cause discomfort or pain to the animals, which is, of course, not conclusive. But it does have an effect, once again, on the animal itself, because the rhino horn, which is still under dispute, but it has a specific utility. And the question then is whether we should determine that those horns are to be used or not. And that is a difficult thing, which can also contradict the integrative approach. So, in essence, let me conclude, because I've tried to portray quite a number of ideas. And it's difficult because this is a very lengthy chapter. It's difficult to just summarize it here. But in essence, the first thing that we can say is in relation to the approach of commercialization and sustainable use, which pertain to this current discourse of rhino horn, one needs to take cognizance of the emergence, and I'm not saying that we have a principle of animal welfare, but there is movement, there is an incremental development which one needs to take cognizance of. Of course, in terms of international law, it's not as strong as the South African issue. Now, I'd like to see the implications in South Africa of this decision. It has not really been, I've not really seen the concrete consequences thereof. So that's the one thing. But clearly, if you have this emerging concept of animal welfare, there is a rising ethical component that one cannot ignore, which is injected in sustainable development and sustainable use in order to pursue a more ethical and humane and compassionate sustainable use. And essentially that could lead to a reconfiguration of this very overtly or diluted maybe form of anthropocentrism and sustainable development that we have in international environmental law, towards what I refer to as a welfare-centric ethic. And in doing that, in taking that development further, perhaps conservation could also be an approach that served the needs of animals rather than merely serving the economic interests of human beings. And with that, I would like to conclude. Thank you very much.